Welcome to everyone. It's a great Tuesday here in upstate New York. We have another packed program for you, including some recent COVID developments. Without further ado, I'm going to get into the first segment today. It's going to be Kate Reed. Kate is a member in our Syracuse office. She's also one of the co-chairs of our school law practice group. Kate is going to give us an update on school law. And Kate, I assume you're going to be talking about something that my children are very happy about. So please take it away.
Yes, it's fun to be a part of our school law practice here at Bond, because even though my clients are just principally public and private school entities, I know that school law impacts almost all of us on the phone, regardless of your industry. You likely know a kid, have a kid in school, have a grandkid in school, and therefore have an interest in what's going on in the state schools. So this has been a very interesting week so far on the masking front. Before I get into the update, I want to make sure everyone's on the same page on how we actually got to today. So back on September 1st, our State Department of Health promulgated an emergency regulation that mandated that masks be worn by all individuals who are medically capable of doing so in a school setting. So that includes staff, contractors, teachers, obviously students as well. Also, since approximately January of 2021, the federal CDC has had a mandate that is binding on all DOT regulated transportation. So that would include school buses, that masks be worn on all school transportation. We've had that statewide masking regulation in effect since September, and then also the federal regulation mandating masks on school buses. So that was basically the landscape. Back in November, the Department of Health re-upped the emergency regulation to continue it through February. And you all probably remember back just before the spring break, the governor indicated that she would be reassessing the need for a masking mandate upon the conclusion of school break to see where our numbers are and whether the mitigation strategies being used by schools are sufficient to control the spread of COVID without the need of mandatory masking. So much to everyone's delight statewide, on Sunday afternoon, the governor issued a press conference in which she indicated that the DOH would not be re-upping the school-wide masking, statewide school mandate of masking. What she did indicate is that schools that are located within cities and counties that have a higher level of spread may decide as a local matter to mandate masking. How that will work exactly, we don't know. There's some question regarding whether, for instance, the county health departments even have the legal authority to mandate that school districts, which are separate municipalities, utilize masks. But what we do know is that there is no statewide mandate effective tomorrow. Also, along with that, the DOT and the CDC at the federal level have also announced that masking on school buses will no longer be required. This is great news. In my business and my industry, there's often not a lot of coordination between the state and the federal government, so we're always happy when they do coordinate and things make sense and they're not stepping on each other's toes. So this would be a case where essentially the masking mandate has been lifted. So there's going to be a number of questions now to navigate for the schools. Principally, are they going to impose a mask mandate as a matter of local decision and as a matter of local governance of conduct on school property? Our practice has taken the position that that would be lawful. There's also going to be now, though, considerable labor relations issues that if you're a parent of a student in a district or you have employees that are parents in a district, you may need to navigate, which include now that you may all recall that about a year or so ago, I was reporting about how difficult it was to get teachers and staff to come back to work after the school closure. Well, we got them all back to work, and now the problem is going to be that many of them are going to say that they do not feel safe in the absence of a mask mandate, universal mask mandate statewide. So we're expecting that there's going to be many different questions. On the one hand, the statewide Union of Teachers, NYC, has issued a memo taking the position that it would be mandatorily negotiable now for a school district to mandate that its staff be masked. Obviously, in a non-unionized private school setting, those considerations would not be there. But in unionized settings, we're going to have at least the allegation now on the part of NYC that masking is mandatorily negotiable in the absence of a state mandate. On the other side, we're going to have staff that are claiming that if all students are not masked at all times, they are at heightened risk of COVID, and therefore we're already seeing, even before the mandate's been lifted, a lot of reluctance on the part of medically fragile staff to come back to work. So all of that is, I guess, more to follow. We're going to have to navigate that for our private and public school clients in the coming weeks. Another issue also that's still out there is that everyone may recall that when the state ruled out the masking mandate for schools on September 1st, they also instituted a test or vaccinate mandate for schools that is similar to, although not as hotly contested and not as litigated as the healthcare vaccine mandate, because there has been that testing opt-out. That regulation actually technically expired yesterday, but we have been in contact with the governor's office and with the Department of Health, which has indicated that essentially that oversight was inadvertent, that the state's intent is to re-up the test or vaccinate rule as well. So we expect that there will continue to be a test or vaccinate rule in place for staff and contractors that are doing business in public schools and private schools for the foreseeable future, although the mask mandate now has been lifted. So that's about the 12,000 foot view of what's happening in schools in New York State. I think I'm out of time, so I'm going to pass it back to our awesome moderator, Adam, to hand it off to the next presenter.
Okay, thank you. I do want to talk or stick on this topic for just a second. Each school district is most likely at this point going to be issuing a communication to parents. I know that I received one. And Kate, is it your understanding that most districts, whatever they're deciding to do, are going to be communicating that to parents?
Absolutely. So this is a time when stakeholder input is absolutely essential for all schools in the state. So if you reside in a school district and you have children, don't be surprised if in the coming days, if you haven't already received it, you may receive a survey. A lot of our school clients are surveying families as well to take their temperature, so to speak, about where everybody's risk comfort is, when they would feel more comfortable having masks rolled out again, if at all. So many of our school clients are canvassing and surveying staff, but even those that are not doing a formal survey, Adam, you're right, they're going to be reaching out with a communication to advise their stakeholders about what their policy on masking is going to be. That may be a couple of days in the works for many schools, because they're also required to coordinate with their health department locally, their county health departments, as well as all of the other districts that compose their geographic region and the so-called BOCES that makes up that region. There's going to be a huge drive for consistency, continuity, and basically a consistent approach on a region-wide basis. So we're going to see a lot of collaboration between districts on that basis. And don't be surprised if you haven't heard anything yet from your particular district, that you will likely be hearing from them in the coming days.
Awesome. Well, thank you, Kate. We really appreciate the update. All right, moving on. I believe I am up next. There I am. You get to see my picture twice today. I'm going to be giving you a quick update on what's going on with COVID-19, in particular, the masking requirement, because there have been some developments over the past week. If you could, next slide, please, Kathy. All right, so what happened on February 25th is the CDC issued its updated masking guidance. I've linked to it here. You'll have the link, which will be live in the presentation that you can download tomorrow from the Schoeneck King website. But essentially, what the CDC said is that if you are in a community that either has low or medium transmission, that there is no mask requirement. If you see under medium that if you're immunocompromised, you're supposed to be wearing a mask, or if you live with someone who is high risk, you should be wearing a mask. But the mask requirement or mask recommendation has been lifted for those of us in either low or medium transmission communities. The CDC provided a really useful tool, and you can see that at the bottom of the screen grab there, you can select your state and then your county, and the CDC will tell you, are you low, medium, or high? And that determines what the CDC's recommendation is going to be for masking in your area. It's a very helpful tool, and it is something that the governor in the state of New York has actually adopted. So here in New York, it's very important. It's helpful. Almost all counties in New York State are low or medium. So this is part of the good news, the continuation of good news. Next slide, please. For those of you who are curious, how does the CDC determine low, medium, or high transmission. They give some information. I've again linked to the website, but here is the chart and table that they provide. It's based on two different statistics. The first statistic is cases per 100,000 within the last 7 days. And then the second statistic, it's broken into two pieces, but it's the new COVID admissions, hospital admissions per 100,000 people, or the percent of staffed inpatient beds occupied by COVID-19 patients. And you can see how the calculation is made and what the CDC is doing. Now, it's not all that relevant because what you will do is you'll go to that first web page, you'll type in your county, and the CDC will tell you, are you low, medium, or high? But here's a little background in case you were wondering. Next slide, please. Okay, so where are we? This is the ultimate question, right? Where are masks still required? If you remember, a couple of weeks ago, I gave a presentation on the context for the mask requirements. We had essentially three sources of mask requirements. We had 10 NYCRR 2.60, which was a regulation where the government articulated a specific mask rule in certain specified settings. You had a commissioner's designation, which was most recently updated on January 31st, which reiterated or repeated what the NYCRR provision said. And then we had the HERO Act. So we had those three different sources of masking rules. We've seen an erosion of the rules in those three different contexts over the past couple of weeks. We saw the governor first lift the general masking rule that was found in 10 NYCRR 260 and the commissioner's designation that applied generally to stores, businesses, etc. That was lifted. We then saw the governor, as Kate mentioned, lift the masking requirement in schools. So that requirement has been lifted. We also saw the HERO Act template plan get updated. And now, under the HERO Act, businesses are not necessarily required to have their employees wear masks at work. So there are, however, so all that's been lifted, but what's left? So we know that masks are still required in a couple of different settings. Healthcare settings regulated by DOH, this includes hospitals and nursing homes. Adult care facilities regulated by DOH. Correctional facilities and detention centers. Homeless shelters. Public transportation and public transportation hubs. And importantly, this includes taxis and ride-sharing transportation. And courts. So this is where, these are the specific settings where mask requirements are still in place. Other than that, there are no mask requirements. This doesn't mean you aren't going to be required to wear a mask in certain settings, because any business, the state's been very clear that any business, if they want to, can have a mask requirement. Your employer could have a mask requirement if they want to. It's just no longer required by regulation or statute. So that is it. I actually, I want to address a couple of questions that I saw in the chat. Regarding wearing masks, does it matter if a person is vaccinated or not? No, that distinction has not been drawn. However, you can, if you want, require unvaccinated individuals to wear masks. So the important piece of what I'm saying is that the state requirements have been lifted to a substantial degree. Okay, I don't want to take up too much more time because we have a lot left to get to. So that is the masking update. Next up, we are going to have a discussion of a new law dealing with pay transparency in New York City. And to deliver that update is an attorney in our New York City office, Sarah Luke. Sarah works with a lot of clients on various human resources and labor and employment issues. So Sarah, welcome. Please take it away.
Very much, Adam. And thank you for the COVID update. It's so nice to hear some positive developments about situations getting better under that topic. So we're going to talk about New York City today, but this is actually important to employers even outside of New York City. And the reason is that New York City is following what we see as a national trend. Legislatures, state legislatures, and city commissions throughout the country are taking a hard look at pay equity and pay transparency. And so New York City is what we're going to focus on, but with an eye towards the fact that even if you're not operating in New York City, these kinds of concerns should be on your radar. So in our case, in January of this year, the city human rights law was amended. And the law now requires that employers include the minimum and maximum salary for a position in any advertisements for a job, for a promotion, or for a transfer opportunity. So that's the plain language of the amendment. And from that, we can draw a couple of conclusions about what we know this law really means, or what this amendment really means. We can go to the next slide. I've outlined them. Well, first of all, we know that the law goes into effect on May 15. And this is important because we have a little bit of time, thank goodness. We know that the law applies to employers who have at least 4 workers in New York City. But it's kind of unique because workers is defined broadly to include more than just employees. So also independent contractors, who we generally don't like to think of as our own workers, they're included in this 4-person headcount. An employer has to make a good faith determination at the time of a posting of the lowest and highest salary. And this is something, maybe we haven't thought of historically, because we don't always include that kind of information in postings. But we know that that will be required. And failure to include this kind of range would constitute an unlawful discriminatory practice under the New York City human rights law. This is kind of important for those who are operating in New York City because the human rights law is enforced by the city commission, and they are a zealous enforcement agency. So we do anticipate that they're going to be paying attention to this compliance area. So we know a couple of things about the law, but the more I thought about this for the presentation, there's quite a few things that we don't know. And I've outlined those on our next slide. So some things we don't know. The commission is expected to issue guidance in advance of the law going into effect. And we hope that that will clarify some of the ambiguities in the current statutory language. So we don't really know what it means to advertise a position, what kinds of postings this would apply to. Sometimes there are work environments where we have internal postings versus external postings. And so I don't know if the law is going to draw a distinction in those terms. There's also times when maybe an employee, maybe there isn't a position that's available generally, but an employee is doing such an outstanding job that you want to promote that person. You want to adjust their job title or adjust their salary. Well, I'm not really sure how that would be addressed through this amendment to the human rights law. So we're hoping that guidance would be issued with respect to that. Not every employee is paid via salary. So there are non-exempt workers who are paid hourly. There are workers that might just be paid for a special project, a flat fee, people that work on commission. And we don't really know what that means in terms of, what's required for postings for those kinds of positions or promotions or transfers. It's also not clear how this would apply to remote workers, or if it would apply to remote workers. Some of these ambiguities come to mind because, as I mentioned, there's legislation like this throughout the country in different states. And so we've seen in some of those cases that the states have addressed these issues, and we're very hopeful that this city will do the same. So you might wonder, if there's all these things we don't know, why am I even telling you about this? Because we don't really know, what the law requires besides the bare minimum. Well, I think the reason why it's important to pay attention to this law now, we know it doesn't go into effect until middle of May. And there's a bunch of things that we can do right now to be ready. And I've outlined those on the next slide. So the first thing that we would recommend, which is like the gold standard of readiness in the area of pay equity and transparency, is to conduct a pay equity audit. And from our perspective, we advise that those kinds of audits are conducted under the cover of attorney-client privilege And that allows you to work with your attorney to make sure that if there are issues with current, when you do your audit and you think, there's some outliers here, and I wonder, this is an old organization and we're not really sure how these practices came to be. You can interrogate those in a way that maintains the privilege, and you're able to, make any adjustments that you need to prior to the implementation of the amendment. If you're not able to do that full-blown, gold standard pay equity audit, I still think it's good to take a look right now at your current practices. So you're going to want to look at organization charts. You're going to want to look at position descriptions. How are we currently paying people? Just even with the naked eye, looking at, are there any outliers? And do we know why some people are paid different from others? The reason why that can come up sometimes is that institutions have long histories, different kinds of pay practices, different kinds of pay philosophies, and people are hired under different circumstances. And none of those things are problematic in and of themselves. The problem becomes when we don't really know why people are paid differently, because if we don't know, then a plaintiff's attorney will come up with a reason, and I guarantee you're not going to like it. So it's better for us to know ourselves and to be able to either defend our current practice, or if we have to make adjustments, that's fine, and we do it going forward. Speaking of going forward, the other thing that we can do is consider how we're training people that are onboarding employees. And are we making sure that they understand, do we understand our pay philosophy? Do they understand our pay philosophy? And is everyone on the same page so that we have consistent practice throughout the organization? Because again, if we can explain why we're doing what we're doing, and if we have good business reasons for them, then that's defensible when this new law comes into effect. And then the last thing, I mentioned that we're going to get guidance from New York City prior to the effective date of the amendment. And so we want to keep an eye on that. There's also legislation pending before the New York State Legislature. And so we're also going to want to keep an eye on that. So just keeping an eye on developments so that we know as things change, or if things are going to change, that we continue to be as prepared as possible. So with that, I'll turn it back to Adam. Thank you.
Sarah, thank you. That was great. And, we've seen a number of times when New York City passes a law, that law at some point will be taken up by the New York State Legislature and become New York State law. We saw it with the provisions to the human rights law relating to harassment and other employment discrimination. And it certainly wouldn't be surprising to see that in this case as well. So thank you, Sarah. We really appreciate that update.
Adam, I'd like to add something. I've had the privilege of working with Sarah Luke on a couple of these audits where we've hired the statistical experts to help us do an internal audit and make corrections. I can't say enough about how much better it is to utilize that process under the confidentiality and determine how you go forward with any adjustments that are prospective, as opposed to having plaintiffs' lawyers in New York sue our client and us deal with 6 years of back pay as well as attorney's fees. I mean, the difference between, as Sarah said, the difference between controlling your own destiny and how you handle your pay equity and pay compensation system rather than have it dictated by a court or a jury or plaintiffs' lawyers, class action settlement or litigation, are worlds apart in terms of what the difference can be. And it's a great way to take your blood pressure and temperature to see whether there's any problems that need to be addressed. I'll stop there.
All right. Well, for those of you who don't know, the person just speaking was Lou DiLorenzo, and I'll turn to our next presentation now. Okay, so we're very happy to have on with us today Lou DiLorenzo and Jeff Keel. They are both senior members in our New York City office. Lou, I think, is based in our brand new Westchester office as well. But Lou and Jeff spearheaded an effort at the firm several years ago to actually write the book on New York State employment law, which I have a copy of and refer to all the time. It is a great manual for any HR professional in New York who has any questions about the employment process, from hiring to firing and everything in between. Lou and Jeff are going to give us a presentation today about a couple of issues. One thing I'll say about the book too, it's very user-friendly because it's based on questions. So each section is based upon questions that you as an HR professional might have, and then takes you through the law on those questions. So what Lou and Jeff are going to do now is walk us through a couple of hypotheticals that may happen to you, may have already happened to you, and give you some advice on how to deal with them. So Lou and Jeff, welcome, and thanks for being here.
Okay, thank you, Adam.
Thank you, Adam.
Lou and I having edited a book where we had to come up with the questions for 500 pages worth of answers, we are the custodians of a vast repository of questions, and we write them ourselves. What our process for this is, first we write them, then we put them in a mayonnaise jar on Lou's front porch for 2 weeks, and then we see if we still like them. And we have two that we like for you today. And the first one, I think, is a very good follow-on to Sarah's presentation, because it is fair to say that in New York State, the entire process of advertising, recruitment, and hiring is full of traps for the unwary. So Lou, if you will extract the first question from the mailbag, let's take a swing at it.
All right. So this letter that came in is from Bob in Buffalo, and he sent us the following question. Andy, my long-term stockroom manager, is retiring next month. He gave me plenty of notice, and I asked him to manage the search for his replacement. We placed an advertisement, and Andy reviewed the applications and came up with a short list of 3 candidates. I recognized one of the 3 candidates right away because he's a guy from my class in high school who didn't get to attend graduation because he got arrested for shoplifting. Andy says I should interview him anyway. Listen, I can't have a thief running my stockroom, which is full of valuable small items. Please tell me I don't have to interview this character.
Well, let me take a shot at that. I certainly feel for Bob, who does not want a thief running his stockroom. On the other hand, when I used to come up with a great excuse for not attending wrestling practice, my coach, Mr. Quinn, used to say, yeah, I'm feeling for you, kid, but I can't reach you. And here, Bob is looking at a universe of problems. I don't want to suggest that you have to hire people you don't like. You don't have to hire people you don't like, as long as the reasons for not wanting to hire them don't touch on protected categories. And there are plenty of them. There are all of the discrimination categories. There are many others. We've got a whole book full of this stuff, which I can't go into, but arrest records are a particularly sensitive area. It's particularly sensitive for Bob here because Andy, who was tasked with doing the initial selection, has already determined that this candidate is prima facie qualified, which pretty much means that the only reason he would be shot down would be on account of that arrest record and not because there was some other reason not to hire him. At least he's entitled to an interview, because what Bob knows is that this candidate was arrested. He doesn't know if the candidate was convicted. He doesn't know about the circumstances of the conviction. All he knows about is the arrest. And this one has a very simple rule. It is illegal in New York to both to ask someone about prior arrests as part of the recruitment process and also to act adversely to someone, whether by not hiring them, disciplining them, or firing them because of a past arrest. There's a very, very narrow exception. You can ask about current arrests, and you can take action because of current arrests. But that's really not what happens very often in the recruitment process. Arrests are untouchable. Now, convictions are not untouchable. If this applicant had been convicted of shoplifting, and maybe he was, it would be possible to consider not hiring him. But if you're going to make that consideration, the New York correction law has a very, very specific process for making that determination, which an employer must follow, because if the employer doesn't follow it, the New York State Division of Human Rights will take and process a complaint. Where an employer properly learns about a criminal conviction, and we'll get to how you learn about it in just a minute or two, the process to be followed is a review process that takes into account 8 factors. Those 8 factors are the duties of the job to be filled, how the conviction relates to those duties, how much time has passed between the conviction and the job application, how old the applicant was when he or she was convicted, how serious the offense was, whether or not there's evidence of rehabilitation, and how serious is the employer's concern. Now, those are kind of blurry factors, but there actually is a sliding scale which applies to them. If we had an applicant for a position as a bank teller who was convicted of embezzlement 2 years ago, we would feel free to tell an employer that you go through the 8-point process and yes, you can down check this applicant, right, Lou?
Absolutely.
Go
ahead.
If we were going to hire somebody for a position which requires driving a car, but not a chauffeur license or a CDL, because that's a little different, but this is someone who's just going to have to drive, and they've got a whole string of DWI convictions, again, we don't have to hire that person. If you're going to hire, if you have an applicant for a job as a children's camp counselor who has a child pornography conviction, that's going to be an easy down check. And the common thread there is a direct relationship between the crime for which the applicant was convicted and the duties of the position. And yeah, the employer would be out of his or her mind to hire somebody with that kind of background. But suppose you had a guy who applied as a position as a construction site carpenter, and he was convicted 5 years ago of carrying a gravity knife. Well, carpenters carry knives all the time. They also carry nail guns and all sorts of other deadly implements. You're going to have a very hard time making that causality relationship argument. If you had an applicant for a teaching position, and Kate Reed will remember this, who was convicted of a DWI conviction when she was 18 years old. Teachers don't drive students. That's a youthful indiscretion. It's very hard to make that relationship. So when we look at Bob's situation, yes, there is some relationship between shoplifting and being the stockroom manager. But the conviction is clearly an old one, since it happened when Bob, who is now a successful business person, was in high school and the applicant was in high school. And it's also possible that the applicant can show some evidence of rehabilitation. I should also point out, when an employer rejects someone because of a prior conviction, the applicant has the right to request a statement of reasons, which must be provided in writing within 30 days, and it has to explain how the 8 factors under the correction law were considered. So you can't make these decisions lightly, you have to follow the record. And I did say earlier, how does an employer learn about a prior conviction? I can tell you how we used to do it. When we would review employment applications, a client would say, I've got an employment application. Would you look it over and see if it's okay? There was a formula we applied. And the question was, have you ever been convicted of a crime, parentheses, a felony or a misdemeanor? If you answered yes, please provide details. A yes answer will not necessarily disqualify you from consideration for the position, but may be the cause for further review. Now that's actually pretty fair and even-handed, but the law on that is changing. Many counties and cities in New York State, and that specifically includes Buffalo, where Bob is writing from, have passed what is called ban the box legislation. And ban the box basically says you cannot ask this on an employment application. There are other jurisdictions like New York City which have gone further. New York City has a Last Fair Chance Act which says you can't ask about convictions and open arrests at any point in the recruitment process until you have already decided that the candidate is otherwise your preferred candidate for the position, and you've made what's called a conditional offer of employment, which is the job is yours, subject only to some further inquiry. And as we get into this in later weeks and months, that also resonates a little bit in considering applicants who have disabilities, which may need reasonable accommodation or may be disqualified. I would say at this point, Lou, subject to your no doubt respectful disagreement, I think I would tell any candidate in the state, give this guy fair consideration. You can't down check him. And if the only reason that you can come up with after you've interviewed him is that conviction, then I think make him a conditional offer and get into the really intensive review. Lou, what do you think?
I think you're brilliant. That's why I'm delighted to have had the opportunity to work on this book with you, as well as everybody else in the department. A couple of practical comments about issues that come up. Sometimes, even despite the ban in the box, we have the situation where one of our existing employees gets arrested for something. And we often get questions, what should I do? This person's been arrested. Part of the issue is going to depend exactly on what Jeff said before. What's the nexus between the arrest and what the person does for a living? If you're covered by a labor contract, for example, arbitrators impose a very high standard of a nexus between what the job is and what the person got arrested for, what the allegations are. A couple of comments on that. First, Jeff gave you some good examples. The law provides two good examples. One is child molester. You don't have to hire to be a nursery school teacher. You don't have to hire an embezzler to be a bank teller. After that, they get very difficult. There's some cases where people have been convicted of murder, apply for a job, for example, on the night shift in a manufacturing facility, and the courts have said that doesn't disqualify the person from work, even though people may be afraid to work with him or her, or we're worried about the supervision. They're not dealing with members of the public. There's no worry about negligent hiring or retention, which we get into when we deal with issues of people having records that we put in a particular category. So one, keep in mind, it gets blurry out there in terms of what's directly related. Second, you want to do your own investigation, right? If you have a situation where somebody's been arrested, we don't necessarily rely on what the police or the prosecutors are going to do. They have a different issue. They represent the public. They plea bargain. They have a different standard of proof. We want to do our own investigation. If it's into the allegations, not the arrest, but rather what did the person do? We might want to get the police file and find out what the witnesses said about what the person did, and then make our decision based on what our investigation reveals. We've had situations where people have been arrested. I can remember one in particular, a gentleman arrested with a great deal of cocaine in his trunk of his car based on a traffic stop. The person worked in an assembly plant, unionized employer. The employer called me and said, hey, this guy was arrested. We want to get rid of him. I said, look, you need just cause under the labor contract. Making widgets on the day shift really doesn't have much to do with cocaine in a trunk. They said, all the money we pay you, this is the advice you come up with, think of something else. So a couple hours later, I sent drafted a letter for the employee and said, we want to do an interview with you on Friday. We're going to have our attorney conduct it. It's going to get into these issues. Did you drive this car on our company property in violation of our no drug possession rule? Have you used these drugs? Have you sold them to anyone in our plant? All questions related to our policies with respect to the workplace. We had no indication that the cocaine found miles away in a car from the plant actually violated those policies, but we have the right to do a workplace investigation. They said, you sure you want to telegraph the questions and the fact that you're going to do this? I said, yes. As expected at the meeting, he and his criminal attorney showed up. His criminal attorney advised him not to answer the questions, take the Fifth Amendment. I took the attorney out in the hall and explained that there's no Fifth Amendment protection in the private sector. And if your client refuses to answer the questions, we'll be forced to draw adverse inferences and terminate him for failing to cooperate in an investigation and perhaps even a violation of our drug policies. We did that. The charges were reversed because the traffic stop wasn't probable cause. Now we go to arbitration over the issue of, did we fire him for just cause? If we had relied on the arrest itself and the conclusion of it, we would have had two problems: no nexus and now no conviction, right? Instead, we did our own investigation, or tried to, ended up with a decision with just cause being found because the employee refused to cooperate. So you want to be careful with these. You want to watch that nexus relationship. It's an area fraught with danger. I'll stop there, Jeff.
Lou, let me add to that because I think you gave an excellent explanation of how important it is to control the narrative. And this is an absolute true life example. We had a public school district client which was educating a very, very medically fragile young man. This poor kid actually needed 24-hour-a-day nursing care because his condition was such that at any moment a life-saving intervention might be necessary. Now, school districts in New York State do have to provide that nursing care when a student is in school, and our client was doing that. But the student had the original helicopter parent, and whatever nurse was provided was too inexperienced, too indifferent, too cold, too warm, too everything, and it was a constant barrage of complaints. Our special education director was at her wit's end, and we came up with a brilliant idea. We said, why don't you offer to the parent that if one of the nurses she has at home, who she praises so highly, will come work for us at union wages, we'll hire the person as long as they can pass the New York State criminal background check. Well, the mother thought that was a great idea. We processed the fingerprints through the state education department, which looks to state and federal conviction databases. And we got back the following report. Nurse so-and-so has been convicted of attempted murder in the second degree and conspiracy to commit murder in the second degree and is cleared for employment. I tell you that because we don't get to make the ultimate decisions. There are agencies will make the decisions, and that speaks directly to Lou's point. You have to have all of your ducks in a row. Now,
So
Adam,
Jeff,
Adam, how are we
Jeff
doing on
is,
time?
yeah, I was going to say, as some people have indicated, our book is a little long-winded. You and I proved it today a bit, and we won't have time for the second hypothetical. But if we do a good job today, Adam has said he may have us back as guests to talk about the mailbag. I encourage you, if you're interested, our book is terrific. The last few months, it's outsold on Amazon, Governor Cuomo's book. It's done very well. It's
Here it is.
almost 500 pages of questions and answers about all these little nuances that, you really need people who have practiced 40 and 50 years and lived through most of them, learned some of them the hard way. It's a good book, and it's written, as Jeff and Adam said, in the conversational tone of answering questions. I think it's a good resource. I think our firm can let you know, I think anybody who's a member of the New York State Bar Association, which is the entity with about 70,000 members that asked us to write it, we did write it for them. It's published by them. Any Bar Association member get it through the Bar Association. Any non-member can get it on Amazon. If you have any trouble getting it, send one of us an email or Schoeneck King an email, and we'll arrange to make sure it gets to you if you're interested.
Well, Lou, thank you, and Jeff, so much for being on today. I will say to anyone, if there's a specific question or topic you want Lou and Jeff to cover, just fill out the form at the end of the webinar and let us know. Thank you all for attending again today. We will see you again next Tuesday.